Thank you for joining us for the Stone Soup Group Family Learning Series on compensatory education for FAPE denials related to pandemic responses. This is part 3 of a 5-part series for parents to educate them about compensatory education for opportunities lost during the COVID-19 responses. This is part 3. And we'll be talking about developing and amending the IEP. I'm Ann Applegate. I'm a consultant to the Stone Soup Group, which is the Parent Training and Information Center for the state of Alaska. This series is funded by a grant from the Alaska Mental Health Trust Authority. Previous topics in the CompEd COVID-19 response series have been an overview of compensatory education, questions about identification of a student with disability, child find obligations, evaluations and reevaluations of students. Today, as I said, we'll be talking about IEP development and amendments, and the future topics are IEP implementation and the least restrictive environment, and ideas for dispute resolution and remedies. The recordings will be available at the Stone Soup Group website with the link here. You can also put it into your browser, Stone Soup Group Events. The outline for today's session will be a quick review of compensatory education generally. We'll talk about some rules about developing and amending IEPs. We'll look through the problems that have been arising commonly during the pandemic and recovery from the pandemic, claims, results, and remedies from around the country. Then we'll have a summary and some quick takeaways from today. To start, I want to go back over some of the things we've already discussed in the previous parts about CompEd, compensatory education. First, compensatory education, CompEd, is a legal remedy that derives from the IDEA. It's used to make up for services that should have been provided to a student but were not. And when the services offered don't provide an appropriate public education that's accessible for a student with disability. CompEd is awarded when services that were on the IEP weren't provided. It can also be awarded for services that should have been on the IEP and weren't. The purpose of CompEd is to put the child in the position they would be in if the district had provided the appropriate services in the first place. The purpose isn't to penalize anyone, but to help the child regain lost opportunity, to acquire skills that they missed, or get services that were dropped. An important thing to remember that we've discussed previously and will address again in this section is that CompEd is not the same as extended year services, which we will call ESY. CompEd, as I said, is different than ESY eligibility. And this chart is a repeat from a previous section, but it's very important for our discussion going forward for recovery service plans. CompEd is a remedy for a past denial, something that was supposed to be provided that was missed. What is owed then is additional education and related services to get a student to where they would have been, but for that denial. It's making up for a gap, a window of opportunity. And what is owed is an amount that's reasonably calculated to result in the student getting back the skills that would have been missed, the opportunity to build further. With ESY eligibility, we're not talking about a remedy for something in the past. It's a forward-looking, proactive, preventative question. The reason that we do it is because there's an expectation looking at a student's past that there's regression over school breaks coming up that won't be recouped in a reasonable amount of time. And particularly when a lack of progress or a regression would impact independence, would stop new skills from being retained. So when that happens, you look at a past pattern that shows regression, you look at progress notes, class assessments, look at screenings or evaluations before and after previous vacation times or times away from school. And then what is owed or what is provided is education and related services over those periods where the regression might take place without them. And the amount is really what is anticipated to prevent that regression within that time period. So really important ideas that somehow look alike. And so people are confusing them, especially confusing them in recovery plans for schools, school districts, and states. A reminder again about the US Department of Education COVID-19 guidance. In previous parts of this series, I have provided specific slides for each of the guidance documents, and I don't need to do that here, but I really want to remind you that the US Department of Education has said that with regard to COVID-19, compensatory education might be necessary if there was a delay in initial evaluations or in eligibility determinations for special education, or in the development or implementation of the IEP, if methods of the service delivery, like remote delivery or hybrid deliveries, weren't appropriate to meet the child's needs, that child couldn't access whatever that method was, then comp ed might be necessary. If some or all of the IEP couldn't be implemented using the method of service delivery available to the schools, given pandemic restrictions, safety plans, and distance learning. If there was a lack of meaningful transition services provided from secondary school due to the pandemic, then compensatory education might be necessary then as well. This is an important one, and one that we've heard a lot from parents about. If a child's behavior was the direct result of the school's failure or inability to implement the IEP and the child's education was disrupted, then compensatory education might be necessary. That's also true if what we were seeing was new behavior that was a reaction to all of the changes from pandemic. Comp ed should be considered according to the US Department of Education COVID-19 guidance. An important part of today's subject, IEP development, is parental participation. So generally, I'm going to review them, and I know this will be a review for some people. Procedural safeguards are the rules that allow and facilitate parents to have the role that Congress intended. They are to be full partners in the IEP team process. They are to be fully informed and to have certain opportunities in the process that are protected by those safeguards. The right to participate in all meetings, to examine all educational records, to present their own reports, and to have the team actively consider those reports. To have an independent educational evaluation at district expense. To be given prior written notice of a district proposal to make changes and an opportunity to object. To have an IEP in a stay put while any dispute is resolved. It's important to know that procedural violations don't all result in a denial of FAPE, but those which deprive educational benefits, diminish a window of educational opportunity, or seriously infringe on the parent's opportunity to participate in the IEP formulation process. Those are per se denials of FAPE. And per se means they're just automatically that way. We don't need to make other arguments about whether or not there was a free, appropriate public education denied. We see these things and we know that there was one denied. Another reminder that's important for our discussion about state complaints later on in this series: who must be at that IEP meeting? This is, of course, going to be review for lots of you, but parents and surrogate parents, a regular education teacher, a special education teacher, a district representative who has the authority to allocate district resources for that IEP, and people who can interpret evaluation results. Now, that's going to be different people depending upon the evaluation. You can have a speech language evaluation, and you will need a speech language pathologist to interpret those results, for example. And the reason we need those people there is because parents are not experts and they need to be fully informed. There's also always a question of who can be there. Parents can invite others with special knowledge or expertise, and the parent decides whether someone has those things. Now, development of the individualized education program, the IEP, is supposed to be data-based about the student, measurable, achievable within the time period, usually a year, individualized, reasonably calculated to enable the child to make progress in light of their circumstances, and then to also have an effort toward providing a challenging education. The content should be the result of collaboration of the necessary people with knowledge of the student and educational expertise. The document itself must be easily read and understood. It should be portable and transferable, not just between schools, but between school districts and even between states. And it should describe and include all the required parts of that educational program that are in the IDEA. I want to focus a little bit more on the placement determination, because that is the place that has produced the most state complaints with regard to IEP development and amendment. So I want to remind everyone that placement is based on the previous levels below it that you can see here in this pyramid. The IEP is at the top, and that's what you get through this process. But the IEP team starts at the bottom, and the present levels of academic achievement and functional performance are the result of all of the evaluations that have already been done in the evaluation summary and the eligibility report, the ESER. But students' individual needs at the next level are discussed based on those present levels. And then there's discussion going up to the yellow level, the next level, of eligibility in specific areas of need. Usually those are related to curriculum areas or social emotional learning, other kinds of areas that are part of a recognized curriculum for students. Coming out of that is a set of goals. What would the team believe was going to advance the educational progress of this student, and how do we create objectives that are measurable and that will work towards the achievement of those goals? Of course, once you know the goals and objectives, then that can say to the team and to the family, what is the necessary service that would meet those objectives? What qualifications are we talking about? What areas are primary? What might be additional areas? Ooh, that sucked. Okay, I'm going to start this one over. I'm going to spend a little time on the placement determination in the IEP development because it's something that arises a lot in state complaints in this area during the COVID-19 restrictions. As you can see from the pyramid, the IEP is built from the bottom up, and the IEP team goes through the present levels of academic achievement, the student's individual needs, eligibility for services within particular areas of need, and then goals and objectives. The services are determined by the previous levels. And accommodations and modifications are those things that allow a student to access those services. Placement is the final decision in the IEP. And that's because placement is not really a place, but a type of environment where the child's IEP in all of these parts can actually be carried out. It's based on the rest of the IEP. So placement decisions are made after all of the individual needs are considered and the appropriate services are described. It can be described as a type of classroom, like a general education classroom or a special education classroom, or a segregated school environment, or even home-based instruction. But the placement itself is not those settings. It's what can be provided within those settings that's appropriate for that student to progress in their education. There's also a consideration always of whether or not that placement is the least restrictive environment, but we'll talk about that in another part of the series during implementation problems of the IEP. Requirements for IEP development applies also when the IEP is amended or reviewed and revised. It has to be reviewed and revised at least annually or as appropriate under the law. And appropriate circumstances would include any lack of expected progress toward annual goals or toward the general education curriculum. It could be based on results from a reevaluation or because there was information about the child that was provided to the parents or by them to the school team, or because the team or any member of the team anticipate that the child's needs are going to be changing. The law also allows a change for other matters. So other matters in the COVID-19 restrictions were often the inability to provide services. Now, it is true that parents can agree in writing that an IEP meeting isn't necessary for an amendment. The parent can waive those meetings. But otherwise, all of the previous discussion about IEP development has to be applied to these changes as well. Now I'm going to turn to some of the recovery services that were offered during and after COVID-19 by state guidance and school districts. States provided guidance to school districts that were systemic fixes, system-wide plans for compensatory services, they were called, for unfinished learning that were open to all students. They were called recovery plans or recovery services. Some of the things that they offered were school-wide positive behavior intervention supports, PBIS, or summer learning acceleration. Instead of the usual offering of a couple of classes of sort of education light in summer school, there was intensive school day learning all summer long. There were extended school year services offered, and something called high dosage tutoring, which is very intensive, multiple times per week tutoring for students in particular classes and ways of following along with curriculum and adding additional learning in an intensive time period. They were created entirely by districts based on state guidance. Parents were not part of that process. It didn't include consideration of individual students' needs and strengths. And they were often offered during the school day, unlike comp ed. I'm going to keep talking about recovery services in this slide because there was another wrinkle. Continuing learning plans were created for groups of students. Again, general education students. Some districts had hybrid plans for remote learning and in-person learning. They were alternating groups of students to keep the number down so that you could do personal space distancing in rooms. And they were augmented by some of the intensive high dosage tutoring. And again, these were for general education students. Some districts also created individualized continuing learning plans. They were called ICLPs, and they were written for special education students. They were hybrids of fixed parts of the general school plan and parts of the IEPs that didn't conflict with the restrictions or with the fixed parts, the structure that already existed in the general school plan. One example included the statement that it contained, quote, core IEP services needed to progress on goals and objectives. Now, as an aside, there is no such thing as a core IEP service. All of the services in an IEP are necessary for a student to make progress on their goals and objectives. Another district's ICLP form included a statement that it had been created outside of the IDEA, so was, quote, not subject to dispute resolution options under that law. The district was essentially telling parents of students with special education eligibility that they would have to accept a substitute IEP called the ICLP that reduced services and changed placement, that changed the determination of their placement, but they could not avail themselves of the state complaint process or the due process hearing procedures that are available under federal law. Other districts just revised IEPs unilaterally to fit in with their compensatory servants models, and they just called it a revised IEP. But they did it without the IEP team or without parent input. In those IEPs, existing IEP services were usually reduced because time at school was reduced or eliminated, or those services were cut. And delivery methods were changed without regard to whether the student could actually access the delivery methods. So, needless to say, the ICLPs or the unilaterally developed IEPs have not fared well in the state complaints that have been filed by parents around the country. I have spent some time researching databases that are that contain state complaint corrective actions, and a few due process hearing decisions, and 1 or 2 court decisions. The court decisions are few because they haven't made their way up to the court level. But the corrective action findings against districts with the individualized continuing learning plans, this is sort of an example of some of them. They were found that the district made decisions related to students outside of IEP team meetings and regardless of any data or any other input from the parents, and therefore violated parents' rights to have the IEP team decide, which is called predetermination. And they also cited unilateral changes to services. Another said that this violates the requirement to revise the IEP as a team when services just change, violates additionally the prior written notice requirement because parents weren't individually given prior written notices notifying of a proposal to change anything having to do with special education and giving a period of time to object. One very big systemic state complaint over individualized continuing learning plans. The result included the statements that 48% of students had issues that should have warranted the IEP team to reconvene and revise the IEP. And that the failure to do that and the ICLPs themselves violated the IEP development, review, and revision parts of the IDEA. Comp Ed was owed to all students in the school district with disability for the period of using the ICLPs. The district had to give notification of this and the complaint corrective action to all parents, and the district had to develop a tracking system to follow Comp Ed for categories of need and also for individuals within each of those categories. So that was a pretty big result, that last one, but the others are similar. The amount of Comp Ed that was awarded depended on how long the state plan or the district plan was in place. Some of them were done immediately, so there was only an order to not implement them. Parents had complained as soon as the plan was obvious to them. And one of the things that's important as an advocate is to recognize that there are terms that are close to each other. Obviously, we've talked about extended school year services and Comp Ed, but districts and schools were confusing compensatory recovery services with Comp Ed, and were conveying that information to parents. So parents in some districts were told that Comp Ed under the IDEA would be delivered through the compensatory service plan, the recovery service plan, which is for a school-wide recovery. One state, after a very fast corrective action by parents, revised its guidance to include instructions to the IEP team that they could consider Comp Ed, which is under special education law, only if compensatory services offered weren't appropriate for the student. So the student didn't make progress on their goals using the general services for recovery of education. Then they could consider whether there was a denial of FAPE sufficient to award Comp Ed, meaning that a student would have to fail before they get something that they're entitled to under the IDEA. Some districts told parents that IDEA Comp Ed was limited to the federal COVID relief Act funding. Now, the Federal COVID Relief Act funding included funding for district-wide, school-wide compensatory services, but it also included reference to comp ed under the IDEA. Regardless, the parent was told that because the COVID relief funding had been allocated by the parts of the compensatory service plan, that recovery plan, that there was no more funding to award comp ed for COVID-19 denials based on failed IEPs or failed implementation of the IEPs. Some districts included an ESY analysis in their recovery plan criteria, and it also included it for students with special education. So language like regression, not recouped, within a 3-month recoupment period after the return to classrooms is what will give rise to a need for comp ed. That's a confusion of those two categories on that table that we looked at earlier. Now, state complaint corrective actions in these particular examples use different ways to get there. But the result was that comp ed under the IDEA is not affected by recovery and compensatory service plans in state guidance and implemented by school district plans. One federal district court judge refused to give deference to a district plan for recovery that included some reference to how comp ed would be owed and given, by saying that the guidance documents are unpersuasive because they lack thoroughness, valid reasoning, and consistency with prior guidance. Just a note that state complaint corrective actions don't have the force of law. Court-made law does, and we are starting to see some of that as these cases make their way through the appeal process up to the federal court. I offer the state complaint corrective actions more as a way of giving you an idea of how many actions, corrective actions, are supporting the understanding that we have of comp ed under federal law, under the IDEA, and also as examples and flags for your own experience. And should you decide to pursue a dispute resolution option, to give you a kind of a template for what looks like a successful complaint in other states. Another thing that arose during COVID-19 restrictions was the frequency with which students had to be in quarantine or isolation. The return to school resulted in exposures in classrooms. Families with multiple children had students exposing one another. People returning to work were exposed. There were people who had vulnerable students and also vulnerable other adults in their households. So there was a lot of repeat return to home for home-based instruction or for a remote delivery. So one of the things that comes up in general when a child with a disability is classified as needing homebound instruction because of a medical problem or as ordered by a physician, if that medical problem is going to require that the student is home for an extended time, and it's usually considered 10 consecutive school days, but if there is a pattern that is predicted to continue, then it can be more than 10 cumulative school days. Then the IEP team has to meet. It's necessary to change the child's placement and the contents of that child's IEP to reflect the growing likelihood that homebound instruction is going to be the method, the placement for the delivery of services. If the IEP goals themselves will remain the same, and only the time in a special education environment will change, then the IEP team can add an amendment to the IEP stating the specific amount of time that the student will be in an educational environment or in a homebound instruction situation. That amendment can be the type that gets agreed to outside of the meeting if the parent waives that in writing, but otherwise it has to be a discussion of the IEP team. This bolded section is from the US Department of Education on COVID-19. If a child with a disability is absent for an extended time because of exposure or COVID-19 infection and the school remains open, then the IEP team must determine whether the child is available for instruction and could benefit from homebound services. Those are services delivered at home. That would include behavior supports and behavioral-based learning. The IEP team then must consider virtual instruction, instructional telephone calls, and other curriculum-based instructional activities to the extent available. Here is the kicker. If a child does not receive services after an extended time, a school must make an individualized determination whether and to what extent compensatory education may be needed, including to make up for any skills that may have been lost. That is relevant to the circumstance where a child is repeatedly removed from class or required to be away from school because of exposures or because of contracting infection. And that time period extends and extends. You get past those 10 days and you have an inability to provide education in the school building and a very limited ability to provide education in the home. That is what Comp Ed is for, to make up for those circumstances. There were some state complaints that I looked at, a fair number of them on delays and some on waiving IEP timelines. And what I did was pull out some examples that reflected the bulk of those. State complaint resulted in a violation when school exceeded the 45-day limit for a March 2020 records request because of school closures, but they found that the delay did not impact FAPE, so there was no Comp Ed award, but there was a violation. Another found no violation of FAPE in a 181-day delay in providing complete records to the family's attorney, where the family had electronic access to some general education records and was given some special education records at meetings. I think that one turned mostly on the statement from the family that they couldn't recall which special education records they hadn't been given. Another state complaint corrective action found a violation when the invitation form for virtual IEP meetings included a statement that parents agree to excuse strict performance of IEP timelines. They had to agree in writing or the IEP meeting wouldn't be scheduled. It was caught immediately. A parent brought it to a state complaint immediately. Otherwise, it would have given rise to comp ed claims according to the corrective action. Another found violation in a 10-month, which included summer, delay in convening the IEP team to revise service delivery, which coupled with a failure to implement the current IEP, which couldn't be implemented because it was in person, resulted in the denial of FAPE and a pretty significant comp ed award. And another was a violation found in a 6-month delay in comprehensive reevaluation, which the school had described as being required, necessary in a prior written notice in early March of 2020, but did not reevaluate until the end of February the following year. And the state complaint officer found that along with other violations, it resulted in a denial of FAPE for that time period because he was essentially operating with an outdated and invalid and therefore inappropriate IEP. So some quick takeaways from today. COVID-19 closures didn't pause IDEA timelines. COVID-19 distancing didn't suspend IDEA requirements for IEP development, revision, or amendment. District COVID-19 recovery plans, also called compensatory service plans, are not comp ed. Eligibility for extended school year services is not the same as entitlement to comp ed, nor is the amount due at all related. COVID-19 relief funding is irrelevant to whether or how much comp ed is due to a student for a denial of FAPE. We'll be seeing more of these topics as the state complaint corrective actions and due process hearing decisions will eventually reach higher courts. One of the decisions that I talked about that was a judge statement in a federal court decision is currently on appeal in the 10th Circuit. So we'll get some, unless that decision is unpublished, we will get some statement from a federal court at that time. I think what's important to remember is that everything that you know already about your rights under the IDEA still applies, and it applied during the COVID-19 pandemic responses. So until we get more information from higher courts that clarify some of the confusion that we've talked about today and get some ideas about how much comp ed is being awarded for various denials of FAPE that occurred because of the restrictions on educational environments. So until we get clearer statements from federal courts, the things to watch for are the things that the IDEA has always watched for. Was the IEP team not developing the IEP? Was it a predetermined set of services? Should there have been revisions to the IEP? Was there an inappropriate delivery of services that ended up being planned for a specific student? What happened with a change of placement or setting? Should the team have considered whether or not services should be added to address that transition or to make that transition work better for a student? Was there a unilateral change of services? What about a change in staff? Especially out of the pandemic with workforce challenges, there have been changes in staff. and look to see if the expertise and credentials of the people delivering services are the same as in that IEP schedule. Is there supervision required, and by whom? How much time is that being done? What about the timeliness of meetings? About progress notes? About the timeliness of evaluations? Are you getting prior written notices? And is there full parent participation in the IEP development? Fully informed, fully participating? Are the evaluations including areas of suspected need that are new needs that have been created by the pandemic circumstances, or from having an inappropriate IEP or insufficient implementation? Those things should be done if there's evidence of new needs caused by the past circumstances. I want to thank you and also thank the Alaska Mental Health Trust Authority and Stone Soup Group for allowing me to share this with you today.